And so this common law came over to the United States. They said if you want to set up a trust, you have to give the trustee some active part, some active duty in it. They have to make decisions with regards to the real estate that it holds. And you could see why, because then it's in their mind, they said, well, then the trustee's actually doing something, and we have more parties involved here, more interests that we're trying to protect. So this was the general common law as was brought over from England. Now, Illinois, they looked back at this and they decided to create a system where they did away with the statute of uses. And they said, you know what, now that the trusts are over here, we will allow by statute people to create trusts where the trustee is there for title holding purposes only. He doesn't have to have any powers over the assets. He just sits there. That's acceptable in our state. And that's where the term Illinois-style land trust first originated, is because they were one of the first states to adopt this type of trust. If you created this type of trust in any of the other states, they would just deem it to be invalid and as if the trust never existed to begin with. So, a few other states now have adopted similar statutes where they allow you to create a trust in which the trustee has no power over the assets. He's there just for title holding purposes. The vast majority of other states, for instance, the state of Washington, requires the trustee has some nominal duties in order for there to be a valid and effectual trust that's being created. They have to do something over that trust. And so when you create a trust, what you will do is you'll typically assign the trustee some duties over the property to collect rents, to make repairs as needed inside of the trust when the assets are held inside of there. Because with the land trust, the control really rests with the beneficiaries of that trust. And so if I set up a trust for myself, a land trust, to take title to property, you have a grantor, you have a trustee, you have a beneficiary. The trust document states that the beneficiary is the one who has the power of sale, that I can decide when the assets are going to be sold. I can mortgage the assets. I can dissolve the trust and pull the assets out. Trustee's responsibilities to rent the property, trustee can repair the property, things like that. So really the control rests with me in that trust. So if I set up this trust, I would deed the property from my name into the name of the trust, and I may appoint somebody else as the trustee of that trust. Why? So now my name's no longer on record. I'm no longer listed as the owner. But I still have the power over that property as the beneficiary. That's how a land trust works. Okay, now why do people use them in real estate? What are they used for? Asset protection. But let's talk about what type of asset protection. Real estate investors have typically used trusts to mask property transfers. Okay? First off, a land trust is a grantor trust. It's like a living trust from that standpoint. A living trust does not offer asset protection to you, okay, because it is a grantor trust. So when you tell people that you've created, you're thinking about creating a land trust, what you are creating is a revocable grantor trust. That means that there's no asset protection for you. So if you went into your attorney here in Washington and you didn't want to have him roll your eyes at you when you're talking about a land trust, what you would do is you'd say, I want to set up a revocable trust to hold title to real estate. Can you do that? Absolutely we can. I know what a grantor trust is. But if you say, hey, I want you to set up a land trust, what is he going to say? You don't know what you're talking about. Okay, so you need to speak in their terms. So always refer to the land trust as a revocable grantor trust. This revocable grantor trust that we see here is made out of what? Glass. So does the glass provide any asset protection for you? It doesn't. So if I put my piece of property inside of here, and I say I called this the Coons Family Trust, you can see right through this glass that who's underneath it? It's Clint, right? See right through there. You see me, because my name's on the trust. If you wanted to sue me in order to get to this property, what would you do? Break the glass, and you get right to the property. It's yours. So, I mean, literally, I like to use cups, okay? Here's the asset protection you get from your trust. Nothing. There's no protection there. And if a tenant sued and the property's held inside of the trust, okay, the trust will collapse around it and you would then be liable for whatever happens. So there's no asset protection with a land trust. They can burn right through it and get to you. If you get sued individually, I can burn right through this trust and get to the property to recover against it.